Hello everyone. In this video, we're going to be taking a look at an article from The Atlantic. Now this was published on December 19th. It's written by Nicholas Bagley. He's a law professor at the University of Michigan, or at least claims to be, but you can see that his lefty, bullshit views trump the actual law in this ideas piece, which I'm assuming is The Atlantic's version of an opinion piece. It's kind of funny because this situation literally changed everything with Obamacare. And they're scared because, oh no, Obama's legacy. What legacy? What he's done is shit. He literally conspired with the insurance companies to screw over the American people. It didn't help them. It screwed over more people than it helped. And that was the intent of it because, we'll give a few poor people and a few, other heart-throbbing, heart-sob story types. We'll help them with some insurance and we'll fuck a lot of other people and we'll hold these people up. Well, the middle class is sitting here going, oh, fuck me, I can't afford insurance. That's what that was. But no one wants to admit that on the left because it doesn't look good for optics. And it's the truth of the matter. Anyway, a case that should have been laughed out of court may kill Obamacare. Oh, no. Wah! Nicholas, do you need a safe space with an assortment of coloring books and a trauma animal to pet? Would that help? An appeals court ruled yesterday that the healthcare law contains a constitutional flaw and that most or all of the law may have to be scrapped. Good. About freaking time. Sorry, Nicholas. So sad, too bad, to quote Hard Bastard. Oh, you poor shitbag. Doesn't it hurt your fifis? In an opinion blending arrogance and cowardice in equal measure, an appeals court ruled yesterday that the Affordable Care Act contains a constitutional flaw and that most or all of the law may have to be scrapped. Now you can tell here that this little shitbag, Nicholas, he's a sleazebag, and his emotions rule over the fact of the law. Because you got to love this. Instead of starting out making a case, he's a lawyer. Instead of making a case on why this was a bad decision, he instantly goes into personally attacking the judge by saying arrogance and cowardice in equal measure. That's an attack. Or the judges. Whatever the case may be. Because some appeals courts, it's multiple judges. Sometimes it's one judge. I believe this was one judge. He doesn't like the fact that the judge looked at it and said, yeah, there's a constitutional issue. And instead of saying, no, there isn't, and explaining why, he goes right off on the personal attacking. That should be a red flag for you. But the court was coy about just how much of the law has to go and punted that decision back to the same judge who, last December, declared the entire law invalid. Oh, no. So there's a constitutional flaw, and you don't like that that's pointed out. And now it's going back to a judge who originally ruled that the entire law was invalid. So you're afraid that he's going to go back and say, yep, the whole thing's invalid, toss it out, which is what a lot of people in this country want. A lot of them are small business owners that can't afford insurance for themselves, that have to keep their businesses within certain size constraints to avoid getting royally screwed and being able, because, heaven forbid, you get a few more employees, get to a point where you get a few more, then you start having it to where your business got to a point where you can actually finally offer them health insurance. There's this arbitrary, number of employees where all of a sudden you have to have it. And some businesses, there's not the margins to do that. But it's a one-size-fit-all. And that's why that's one reason why the economy stagnated under Obama. But no one wants to look at that fact. Because you actually had business owners that went forward at publicly speaking about this. There was one, what was it, the CNN thing with Bernie Sanders with healthcare. Was it the one that he did with Ted Cruz? Or was it one that he did by himself? But anyway, a lady who owns a salon, she didn't have insurance and she couldn't expand her business because if she added one more employee, she had to have insurance, but she couldn't afford it. And there's low margins on stuff like that. Because it's when people are getting their hair cut, it's not like a steady flow of business per se. And the cost for a haircut, I mean, they're not that cheap these days, but they're also not that expensive. It's not like a higher price, higher ticket item where there's more margin to it. This is so sad that these idiots are upset. They're losing, and they don't like it. I mean, the video I just did, you get them freaking out about the sanctuary cities with the for Second Amendment protection. It's so funny. They're losing and they're freaking out. What happens next is uncertain. The Supreme Court might choose to hear the case, Texas versus United States, right away, setting up a constitutional showdown that could become the centerpiece of the 2020 presidential election. Or the justices could wait until the lower court rules, leaving the fate of Obamacare in limbo for years. Not really. Not really. Because the lower court rules, they can just choose not to hear it. They can just choose not to hear it now and let them do it. See, this is the thing. He wants the Supreme Court in thinking these are the days, when you had Scalise, working along the lines of agreeing with that stupid tax bullshit just to fucking keep the peace, which it looked like they had some shit on him. And maybe he had a conscience, and that's why all of a sudden, at a Democrat kingmaker's little personal place, he happens to fall ill, die in his sleep, and then there's no autopsy, and he's instantly embalmed. Think about that. Oh, no. See, they think it's those days. Those days are over. Let it go to the Supreme Court. They're just going to laugh you out of it and go, you're the ones that are shipbricks. You don't understand. It's no longer constitutional. Fuck off. See ya. I think that's actually what they're kind of afraid of. I think that's what Nicholas here is afraid of. So he's going to play the game and make it sound like, oh, well, it'll go there and it'll be work in their favor. And he's just looking for a reason to bitch and try to slander this judge and the lower judge. Or he honestly believes that they can do something. Who knows? Neither outcome is good. Well, of course not. But you're still using it to try to attack the lower court. And it's all completely unnecessary. No, it's not. The case is a partisan stunt that has been roundly condemned by lawyers on both sides of the aisle. Really? Excuse me, but almost everyone on the fucking right is against Obamacare, you dumb fuck. Since when? If you're talking about neocon shitbags who are getting money from the insurance companies, maybe, because it was designed to make it so that only the big insurance companies would survive. That was the intent of it. To wean out the weak from the market and put them in control of more of it and force people to have to purchase a service that has less competition, that is more expensive than it was prior to Obamacare. It should have been laughed out of contention long ago. Why? Because you say so? You wannabe fucking lawyer hack who lets his feels over reels trump his shit? Dude, you should not be teaching people the law. The law isn't about feelings. It's about facts, and you don't have them on your side. The opinion from the U.S. Courts of Appeals for the Fifth Circuit is an embarrassment both to the Republican-appointed judges who put their names to it and to the federal judiciary as a whole. The third judge on the panel, appointed by Jimmy Carter, dissented vehemently. Of course Jimmy Carter's little bitch would dissent vehemently. Because for whatever reason, there's this mentality that there's got to be this preservation of Obama's shitty-ass legacy. And it don't matter if it's right or wrong. People on the left will do anything to try to protect it. And that was a case of this here. And just because those other two judges were Republican does not mean that the law is no longer constitutional. It does not mean that it's not constitutional. Sorry, let me rephrase that. That didn't come out right. Because this court ruled that it's not constitutional does not mean that it is not constitutional. It means that it is in most cases. I bet you the Supreme Court would come to a similar finding. But that's what you're afraid of. You're afraid that this is going to actually have more precedents showing that it is, because this was unconstitutional to begin with. People were saying it was before it was even passed. This has been a long-standing thing, and they're trying to play it like, oh, well, it's constitutional. Why? Because there was like politicking and blackmailing going on with the Supreme Court to have it say it was a tax to force people to either get insurance or pay money out of their own pocket to the government? Come on now. The case centers on the individual mandate, the requirement that all Americans secure health insurance or pay a penalty. Back in 2012, the Supreme Court held that Congress didn't have the power to coerce people into buying health insurance. Yes, which is exactly what they did, which is why there was backroom politicking and there was some blackmail with like Scalise to get them to go and say, oh, well, it's a tax. If that's what the individual mandate did, it would be unconstitutional. And that was the most straightforward way to read the law that said that people shall buy insurance. But the court reasoned all the constitutional difficulties went away if the law were read as imposing a tax on the decision to go without insurance, which that was never the intent of the law. It was written specifically one way. You can't then say all of a sudden, oh, we're going to interpret it this way because the language says it's one way. You can't all of a sudden say, oh, well, that same language now all of a sudden means this. That's not how it works. And now that that's coming to fruition where it's like, oh, it doesn't exactly work because there's been cases to whittle away at this, they're freaking out. Obama's legacy. Oh, no. That would give people a lawful choice about whether to buy coverage or pay the penalty. And so the individual mandate was saved. Right, but the thing is, that's not a lawful choice. You're literally holding a gun to someone's head and say, you either give them your money or you give it to us. That's not a lawful fucking choice. That's fucking extortion. That's criminal. You either give it to these insurance companies that wrote the bill with Obama, or you pay this exorbitant tax. That's not a choice. That's blackmail. It's extortion. It's literally what the government's gun to your head saying you will pay this or else. That's not a lawful choice. Republicans never really accepted this outcome. No, a lot of people didn't accept that outcome on the left or the right. In 2000, well, I should say the false paradigm of the left or the right. In 2017, they tried to repeal the Affordable Care Act, but they didn't have the votes. As a consolation prize, they zeroed out the penalty. Now, if you go without insurance, nothing happens to you. Yes, exactly. And I got no problems with that. I'm perfectly fine with it. A bunch of attorney generals in red states saw an opportunity. You mean they literally saw the fact that now there was a means for them to actually go after the law? And you don't like that? They realized that the penalty's elimination meant that the mandate didn't look like a tax anymore. It didn't look like a tax in the first place, you dumb shit. You even said up here that if you read it the way it was written, okay, it doesn't sound like a tax. It wasn't intended to be a tax. You don't say that directly, but you kind of get to that. And then here you go and talk about it. It didn't look like a tax anymore. It wasn't a tax in the first place. They filed suit in Texas and pressed the argument that the word shall in the instruction to buy insurance must now be understood as an unconstitutional obligation. It was one before that. But you had backroom dealing. You had Scalise getting blackmailed up from the looks of things. And maybe some other people on the Supreme Court. And that's why, Scalise, just happens to go to a Democrat kingmaker's, personal little resort. And, I don't feel well, and then goes off and dies. With his body being, quickly rushed off to go and being bombed and everything else and nowhere near the location. Yeah. Real shady shit there. And they want to talk about unconstitutional? And it is an unconstitutional obligation. The whole thing was unconstitutional. What's more, and this is the really audacious move, they argued that this $0 unenforceable mandate is so crucial to the operation of the Affordable Care Act that the whole law is now invalid. Yes, because it is. And that's not audacious. It's the truth. Because it's saying that The main core of it is you have to buy insurance or pay the penalty. And now that the penalty's gone, the whole foundation of Obamacare is crumbling away. Obama's legacy is about to come crashing down on the note of this. Judge Reed O'Connor, the conservative Fort Worth judge who heard the case, bought the argument hook, line, and sinker. Bought the argument. It's a valid argument. You make it sound like it's a shit argument. It's a valid one. The Trump administration also got in on the action and has argued that the law is completely invalid. The case was appealed, and in yesterday's opinion, the Fifth Circuit signaled that O'Connor basically got this one right, because he did, and you don't like that. Wah, freaking wah. The court's opinion contains a lot to dislike. There are gratuitous partisans aside. Some opponents of the law assert that the goal was enacted as part of a fraud on the American people. Yes, it was. It was written by the insurance companies with the Obama administration to force people to buy a service from them. Well, it wiped out the smaller and independent operators from that particular industry. How is that not fraud? How is that not a criminal conspiracy? How is that not a crime? You're a lawyer. Answer those questions, shitbag. There's the indefensible holding that 2 Texas consultants have been injured by a law that cannot be enforced against them. And there's the casual disregard of the prior Fifth Circuit case that a tax can't be collected is still a tax for constitutional purposes. That doesn't matter. See, this is how desperate he is. Because that first element is no longer valid about that law, about it being a tax. Now the law itself falls under different circumstances legally. Now it can be challenged under different premises. And he does not like that. So he's still trying to hold it under the previous premise. Because now the circumstances have changed with the law. Its constitutionality has also possibly changed, which in this case it has. And he does not like that fact. Okay, I'm no legal genius. All right, I'm no JoJo the Idiot Circus Boy. But I got enough common sense and intelligence to understand such basic concepts. This is ridiculous. These people, they don't like losing. It's so funny. But the core of the case is the Fifth Circuit's conclusion that the $0 individual mandate imposes a coercive command. Yes, it does, because you're not saying that you're going to be penalized. You're just saying you have to get the insurance. It's telling you have to get insurance, period now. End of story. It is an individual mandate, not an individual suggestion. Exactly. Because it mandates you, and it says you either do this or that, and now there's no longer that. They're telling you to do this, you dumb shit. But you see, you don't want to deal with that little problem with the situation. Before the penalty was eliminated, the court reasoned people had a choice about whether to buy insurance. It's still not a choice. You have a gun to your head. You either pay the government your money, or you pay it to some corporation that conspired with elements within the government in the Obama administration to write the law to specifically force you to buy insurance. That's not a choice. And no one argued that really when it went before the Supreme Court. But when Congress eliminated the penalty, it must have meant to subject people to government compulsion. The law is only cognizable as a command. Yeah, it is. It's literally now a command. That's balderdash. Bullshit. If you're using the word balderdash, dude, a word that people in their 80s don't even use, you know, the greatest generation may have used that word. People before them might have used that word. But, dude, get with the times. When you're trying to say, oh, that's balderdash, you have no argument. Eliminating the penalty was Congress's way of giving the people freedom to drop their health insurance if they wanted to. Congress didn't mean to force them to do anything. Bullshit. Bullshit, bullshit, bullshit. The Obama administration intended to force them to do it. That's why they couldn't get the law to read it before they had to fucking vote on it. Holy sweet Jesus, you dumb shit. You sleazy, dishonest, dumb shit. You think this is going to fly? This is a magazine that's supposed to be for intellectuals, or at least it used to be. The Atlantic. Now it's a fucking joke when they put idiots like this in there. God damn. I'm not just saying that. When the Supreme Court interpreted the Affordable Care Act back in 2012, it held that the individual mandate gives people a lawful choice. How is it lawful? You have a gun to your fucking head and you're told you either give us your money or you give it to the insurance companies. That's not a lawful choice. That's not a choice at all. I should have the third choice and say, I don't want to give either of you my goddamn money. That's a lawful choice to say, no, I'm not going to give you my money. That wasn't a tentative provisional conclusion. According to the Supreme Court, that's what Congress meant when it used the word shall. No, they meant you will get insurance or else. That's how it was written, specifically to force you to get insurance. They even said that when the law was being discussed and when it was passed, that you are being forced to either pay it. You have a choice. Even though it's not a choice, you can either give us your money or you can give the money to the insurance companies. That conclusion is still the law of the land and it's binding on the lower courts, even courts that really hate Obamacare. Right, but this isn't about that. This is about the fact that that's no longer part of the actual law now. It's moot. So now it changes the whole meaning of it. But you don't want to admit that. Whether the mandate is still a tax or for constitutional purposes makes no difference. The law's meaning that gives people a choice stays the same, even if the constitutional terrain shifts. No, it does not. If the constitutional terrain shifts, now it comes into question whether or not the law is constitutional. That's how it works. Otherwise, the Supreme Court has written, every statute would be rendered a chameleon, its meaning subject to change depending on the presence or absence of constitutional concerns in each individual case. No, that does not apply here. That's not how things work with this. This is a broad scope of a situation. This is not, depending on the presence of absence of each individual case, this is about the fact of the constitutionality of a federal fucking law that has changed because of a ruling of another court. Now it's constitutionality is being called into question, and it is right to go and confer and put the legal challenge there and have a judge decide that. It is the zeal to take down the Affordable Care Act, however. The Fifth Circuit sidestepped the pesky legal niceties that normally restrain activist judges. The arrogance is breathtaking. Excuse me, every fucking judge Obama appointed is an activist. Okay, now Jimmy Carter's used to be kind of legit. They've become activists. Okay, oh shit, Bill Clinton's? They've become so fucking activist it's not even funny. The Ninth fucking Circus is almost all exclusive, Democrat appointed fucking like by majority. Okay, and they're activists out the fucking asshole. And you want to talk about judges actually interpreting the law rightfully as activist judges? Dude, get bent. You projecting piece of shit. This guy's a fucking joke. Which brings us to the cowardice. Having declared the mandate unconstitutional, the judges had to confront what that meant for the rest of the Affordable Care Act, the exchanges, the subsidies, the Medicaid expansion, and all the rest. Yeah, they had to. That's exactly, excuse me, if a law is ruled on, if a court rules a law is unconstitutional, the judges aren't there to fucking preserve the Congress's work. They're there to fucking say, hey, Congress, you fucked up, you dumb shits. This isn't constitutional. Go back to the drawing board or just give this one away because you ain't getting it. The general rule is that a court's job is to preserve Congress's handiwork and that any unconstitutional part of a law should be severed, if possible, from the rest of the law, which is exactly what they did. And in doing so, it brought the constitutionality of the rest of the law into question. That's exactly what they did. In this case, faithful application of that rule yields a simple answer. The court should strike down the unenforceable mandate and leave the rest of the law alone. They did that. The court did that. This is what's fucked up. The court did that. Now, someone comes along, sees that part of the law has been struck down, and it now questions the rest, brings the rest of the law into question with its constitutionality. So they challenged it. They bring it in front of the judge. It's a valid fucking thing. But this asshole don't like that because it's about to dismantle all of Obamacare. And he's freaking out. So he's trying to make this bullshit case that it should just be left alone. But he's ignoring the fact that what she just said here about the whole severed thing. They severed that part of the law from it. And in doing so, the rest of the law is now in question. It's legit. And that's what he's afraid of. Nicholas, dude, go to your safe space. Get your coloring books, the trauma animal, and relax. The Fifth Circuit could have said that, but it didn't. Instead, it criticized the district court for taking the blunderbuss approach of invalidating the entire Affordable Care Act. Aren't there some parts of the sprawling law the court mused that don't have much to do with the mandate and might be left intact? No, not really. Because you want to know why? It all stems on the fact that it's built off the foundation that you have to get fucking insurance. And now that there's this, you don't have to pay the tax penalty. Well, I shouldn't say tax penalty because that's what they called it. But the extortion, because you don't have to pay the extortion. Now it's saying that you have to get insurance, period. End of fucking story. You can't do that. That's why this is being brought into question. Oh, but you don't want to admit that. Maybe the part requiring calorie counts to be posted on menus at chain restaurants, or the parts that took effect before the individual mandate came into force, like the one allowing children to stay on their parents' insurance until they're 26. We can revert back to the previous laws on stuff like that. They're still on the books. Easy said and done. Figuring that out, the Fifth Circuit reasoned would require a careful, granular approach to the law, but O'Connor did not do the necessary legwork of parsing through its over 900 pages. So, the underlying foundation that everything's built on, that you have to get insurance, was just blown the fuck out of the water. That means the rest of it is shit. They can now take what's left of that law if they want to, if the Democrats want to take, like, say, the calorie counts and all that other stupid shit and the insurance at 26. If they want to submit that as individual laws, they can do that. And he didn't adequately explain his conclusion that Congress's elimination of the individual mandate is evidence of an understanding no part of the ACA could survive without it. How no? How? Excuse me. It's the foundation for it all. If you literally blow the foundation out from under a building, is the building still going to be standing? Of course not. Holy shit. So the court instructed O'Connor to try again, not only this time, to employ a finer tooth comb. Maybe at the end of the day, the court said, the entire ACA really is invalid, or maybe just big chunks of it are, or maybe even the vestigial mandate can be severed altogether. Who knows? So, dude, you're just upset that it's going back to a judge that already looks at it and goes, this is fucking ridiculous. And is going to have a field day with it. Oh, so sad, too bad. Or too bad, so sad. Actually, is how Hard Bastard says it. Deal with it. I wouldn't take that judicial shrug too seriously. O'Connor has already said that, even if he were to parse the law's provisions one by one, his conclusion would be the same. Yeah, because that's the foundation of it, the mandate. If you get rid of that foundation, the building can't stand. Or the law, in this case. We can be pretty confident about what he'll do with the case on remand. The writing is on the wall for the Affordable Care Act. Yes. Fucking right. Yes. The Fifth Circuit's cowardice may be strategic. Their cowardice. I love this because they didn't rule the way he wants. They're cowards. Because they didn't rule in violation of the law and they ruled with the law. They're cowards. These idiots on the left, they've got like this like Orwellian view of the world. Like they're the people that are behind newspeak and shit. Words don't mean what they used to mean under these idiots freaking not control, but under their like use and view of the world. By refusing to say how much or a little of the law has to go, the opinion avoids creating an immediate headache for Republicans going into the 2020 election. How the hell is that a fucking headache for Republicans going into the 2020 election? A lot of them wrote in on fucking Trump's fucking coattails saying we're going to get rid of Obamacare. That's why people voted for them, you dumb shit. You are a delusional dumb shit. And you went to fucking law school, dude? You're teaching people the law? Dude, you're a fucking moron. It may also reduce the odds that the Supreme Court will review the case right away. The court doesn't normally like to hear cases before they're wrapped up. Wow. You're really trying to paint this in a particular light that completely goes against the reality of things. Holy shit. This guy Nicholas is a dipshit. And he's a fucking lawyer. Well, wait a minute. He teaches. Okay? Real lawyers practice the law. Hacks who can't cut it, they teach. Nothing about this case is normal, however. The Attorney General of California, Xavier Becerra, has already announced that he's heading to the Supreme Court. Oh, well, he don't like the fact that this could royally screw Obamacare. And with them giving fucking Obamacare insurance somehow to illegals using federal money from part of it, like giving them Medicare and all this other shit, somehow they're managing to give it to them. This really fucks California on trying to get their illegal vote. Huh. Oh, so sad. Too bad. Too bad. So sad. Whichever way it goes. Oh, you poor bastards. You don't like losing, do you? It only takes 4 justices to take a case, and maybe the 4 liberals will roll the dice. They're in the fucking minority for the most part. After all, Chief Justice John Roberts has turned back 2 much stronger challenges to the Affordable Care Act. No, this is way stronger. They're trying to play this down. They don't want the people to see that they are really freaking out about this. This is a weaker challenge. No, this is much stronger because they severed that part of the law off. Now the rest of the law comes into question via its constitutionality because now it's saying you have to get insurance. It's not that you have to get insurance or pay a penalty. It's you have to get insurance. Which basically makes every American breaking the law that doesn't get insurance. That's one thing they also leave out because it makes all these Americans that don't into criminals. He's unlikely to endorse a lawsuit this silly. Wow. They are so desperate. They're using, like, instead of actually attacking what this is, like, basically going to court for on the note of, like, the Affordable Care Act, like the actual merits of what's these people have brought the case are going on. They're like, it's like personal attack type shit. It's so funny. Oh my God, this is fucking hilarious how desperate they are. And waiting could be risky. 2 of the liberal justices are in their 80s, and President Trump would replace them with hardliners if given the chance. Oh my God. Conservatives are fucking hardliners now. Constitutionalists are hardliners now. And that proves my point. They're scared shitless. They're looking at Ginsburg just hanging on. And they're freaking the fuck out. Holy shit. I love how they admit their fear at the end here, or at least Nicholas admits their fear. Let me guess, he was probably one of the ones that said, oh, they should stack the court. I wouldn't doubt it. For now, the Fifth Circuit's decision changes nothing on the ground, but it stands as evidence, if any more were needed, that traditional legal restraints have become fragile in a time of partisan warfare. Whoa, 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 dipshit. That's no. You actually have judges that are following the fucking Constitution. Okay, you have lawyers that are looking at something and saying, well, this section of the law has been removed from it. It's been truncated from it. It's been cut from it. That means now this law reads this way. And they say, maybe we should challenge this and find out if it's constitutional, if it's even legal. It's valid to do that. It's reasonable to do that. It goes before a judge. A judge looks at it and says, oh, no. Nope, sorry. I'm looking at that and it's not valid. Now, it goes to the higher court. The higher court looks at it and says, yeah, it's not valid. Kicks it back down and says, you deal with it. And you don't like the fact that it went back to a judge who's not a fan of Obamacare. You're freaking the fuck out. You're like, Obamacare is going to end? Oh, no. Yeah, and then we might actually have better insurance options because you won't have the insurance companies conspiring to, or the large insurance companies, I should say, conspiring, to corner the market like they did. And you might actually get a little competition. You'll have stuff going across where insurance companies can sell insurance across state lines. And people's coverage might improve. And they might actually get better care as a result for less money, as opposed to the government-run fucking bullshit that caused them to pay through the nose for health care. Anyway, I've covered this well enough. Nicholas is a shitbag, and you can quote me on that. I'm just going to leave things here.
If you liked this video, depending on where you are watching it, please give it an upvote or thumbs up. If you want to know when new content of mine hits the internet, don't forget to subscribe to one or more of my social media or video accounts listed here. Also, with YouTube, don't forget to ring that bell. You can find all of my video content on both BitChute and YouTube. This may not be the case with other places I upload to, but I will try to minimize this happening. You are always welcome to interact with me at any of these sites on the list, so feel free to do so. If you have anything you want me to cover in a video, when it comes to news or current events, send it right along to me. I will try to do my best to cover it. As always, thank you for watching.